appeal in the matter of İŞBILEN and Turk.
Yes, Mr. McCall.
My lords, my lady, I was dealing in greater detail with ground 2 when you rose yesterday. There is no coherent challenge to the judge's legal ruling that in the events that happened, the deadline for compliance was the 22nd of March. Given that, and given the judge's unassailable factual findings as to Mr. Turk's understanding by the 18th of March and a fortiori the 22nd of March, there is no need to determine on this appeal whether a forthwith disclosure obligation is continuing. However, it is of course a question of practical significance more generally, and so the court may wish to give guidance in relation to it. In my submission, a forthwith disclosure obligation is obviously continuing, in the sense that if a respondent fails to give the requisite disclosure by the date by which a diligent respondent would have done, they are not relieved of the obligation. That is consistent with and reinforced by the decision of this court in Solodchenko, as I said yesterday. If I might ask my lords, my lady, to turn that up. It's at page 548 of the authorities bundle. It will be in your volume 2, behind tab 12.
Sorry, 548.
548 was the page. If we could go just to paragraph, it's paragraph 15 of the decision I wanted to go to first, my lord.
15.
15, just to show, my lords, my lady, the disclosure obligation. It's at the bottom of paragraph 15 around letter D, just to show you that what was required was written answers to the Schedule D questions within 7 working days.
Yes.
That was the obligation. So it's an obligation with a specific deadline, but one that this court treated as a continuing obligation, and we see that from paragraph 55, to which I think I referred yesterday but didn't take to court. That's at page 554. It's here that the court at Roman 3.
Continuing failure, yeah.
Continuing failure, my lord, has the point.
Yeah.
And then 56, in the case of continuing breach. So following the analysis of this court in Solodchenko, the forthwith obligations are continuing, and the breach is properly characterised as a continuing breach. And that is not to undermine what Lord Justice Nugi said in Kia, to which I will come in due course, because it's a quite distinct question, as I will show the court, that Lord Justice Nugi was addressing. And just to explain that.
I think yesterday you said that the breach takes place on the deadline, but it becomes what you call a committable breach if nothing's done to put the situation right.
Yes, well, it certainly becomes a breach on the deadline, but with the forthwith obligation, there's a difficulty in ascertaining the deadline.
Yes.
Because I thought about this overnight, my lord, in response to one of your questions. The deadline for a forthwith obligation in relation to a particular piece of information only comes to the courts and the applicant's awareness, in most cases, either when the information is disclosed or when the non-disclosure is discovered, unless the disclosure is very straightforward, because this case illustrates that well. The information contained in the SGP bank statements, which were in Mr. Turk's email inbox, was readily disclosable by Mr. Turk, because all Mr. Turk had to do was search his email inbox. So the forthwith deadline for that information was relatively tight. In contrast, where information was contained in bank statements to which Mr. Turk had access, but which were not available online and which he had to request copies of, the forthwith deadline would be more generous. But we couldn't know that, the court couldn't know that at the time of applying for or granting the order. And so whether there was a breach as at the deadline is a question to be assessed realistically only with hindsight. But my lord, in my submission, the court has my overarching submission that all of this is academic, but
Yeah.
the second submission is there are a number of ways to skin a cat, all of which might be right. So one can analyse it as the breach occurs at the deadline, but then becomes committable, may be committable obviously at the time, or may become committable subsequently. Or there's a contempt at the time that is then for the respondent to purge. Or third, there is what is properly characterised as a continuing obligation as per Solidchenko. And I'll seek to support that analysis further given its practical and general importance. Fourth, if there isn't a continuing obligation, there is a continuing breach, which was a distinction my lord drew yesterday.
Yes, I mean, because the paragraphs you've taken us to, 3 and 56, do not actually use the word obligation. It's a continuing failure and a continuing breach.
Yes.
Because I think you submitted yesterday that it's not a continuing obligation in the sense that each day there's a further committable contempt.
Exactly so.
Because if there was a continuing obligation, then arguably each day there would be a further committable contempt.
Yes.
And I think that's the problem if you call it a continuing, speaking for myself, if you call it a continuing obligation.
I quite understand, and as I said yesterday, to an extent it's a semantic question, but I am absolutely saying it is not a separate committable breach with every day that goes past or every instant that goes past. I suppose it would have to be. The point is well illustrated by Jones, my lord, because the breach was failing to deliver the child by the specified date. That breach continued, but with each day that passed, there wasn't a further committable breach committed. That's what was decided in that case. But the absurdity of Mr. Turk's position is illustrated by considering whether the mother in Jones could have said, I know I was obliged to deliver my child by the prescribed time, and I didn't do that. So you may punish me for that, but I'm not obliged to deliver the child up anymore because the obligation was fixed in time. There was obviously a continuing obligation to perform the thing that she was obliged to do by the court's order. And one can analyse that, as I say, in any number of different ways. But she was in contemptuous breach. It was a continuing breach, just as Mr. Turk, in this case, was in contemptuous breach as soon as the deadline for forthwith disclosure lapsed in relation to a particular piece of information and in unpurged contempt. In Kia, the point, I think this may have chimed with another of the points raised by my lord yesterday. The reason why Lord Justice Nuji even analysed Jones was because one of the alleged breaches in Kia concerned a transaction, the entry into of a mortgage, that post-dated the deadline for disclosure. What the order did not do in Kia, and did not do in this case, was impose an obligation to give rolling disclosure, or keep updating the position as to known whereabouts. It was snapshot disclosure, if I can put it that way. And so in Kia, there was no breach because the thing in respect of which the applicant sought to commit Mr. Watson had not yet happened. That's not this case. All of the things that had happened to Mrs. İŞBILEN's money on our case had happened long before the order was made, and Mr. Turk failed to give snapshot disclosure. But there was no rolling disclosure obligation on Mr. Turk. Of course, as a matter of practical reality, the proprietary injunction stopped him, restrained him from doing anything else with any of the relevant assets. So there was no need for rolling disclosure. The scheme was, tell us where the money is or where you last knew it to be, and don't do anything else with the money. And so it's importantly distinct from Kia, but this court does not need to disapprove Kia or disapprove Jones in order to hold that a forthwith obligation is continuing in nature, or that a breach of it is a continuing breach. As regards the cases that my Lord Justice Lewison cited yesterday, the efficient Mr. Gurr has produced a clip of those decisions. The Singapore decision, we just have a transcript of, because Lincoln's Inn Library had a power cut, so we weren't able to photocopy the report. But if my lords, my lady would like a copy of the report in due course, of course we can provide it.
I think it would be helpful.
We've got it electronically.
You have.
A paper copy of the full report we are awaiting. Mr. Counsel helpfully says he has a paper copy. I think we do. Right. Well, I'll let him stand up in due course. But my Lord Justice Lewison is obviously familiar with the decisions, but they all, in my submission, just reinforce and are consistent with my analysis of what a forthwith obligation is. It's not an obligation that, once the deadline passes, magically evaporates. I risk just repeating myself, but if a respondent doesn't try to comply, they can't then say, ha, the deadline by which a respondent would have complied if they were diligent has passed, and now I'm no longer in breach and I'm no longer in under any obligation.
Yeah, but if one tests that, if somebody was not capable of doing it, I mean, this is one might say that there's a unfortunate opaqueness in the word forthwith, because as you said, it depends. And when one's seeking to commit somebody, having it depends is not a very helpful element to introduce. And so that it comes down to the word practicable, doesn't it?
As soon as reasonably practicable. And my lord, it may be a relatively rare case that a respondent is committed for breach of a forthwith obligation. But here, the justification is plain. The judge held that Mr. Turk did not embark on the exercise. Right? That's the overarching contempt. That's how I opened the committal application below. Is there are these sub grounds, but the main ground, which is as serious as it gets, is not even trying. Understanding the order and not even trying. And that's what makes it obviously committable. And then other committable contempts may be uncovered, where, as I said to my Lord Justice Lewison, a non-disclosure is discovered, and that's what happened in relation to specific counts in this case. An applicant is able to say, oh, well, he obviously could have got that piece of information because it was in an email inbox, and he failed to give it, so that's approved contempt. So there's no problem in principle. It's very clear that a forthwith obligation is enforceable by way of committal, and most obviously where a respondent doesn't even try. Therium, my lords, my lady, is a decision of Mr. Justice Popplewell concerning a proprietary injunction, and there was an order in relation to claim proceeds.
It was paragraph 30 and 31, I think.
That's where I was going to go. I was just telling you about paragraph, the context for the decision, but yes. But so paragraph 17 gives the context, so paragraphs 14 and 17 give the context for the decision, my lord. And then it's 30, 31 and 32. And importantly, as in this case, it's not only the proper construction of the order, it's how the respondent understood it. I showed my lord and my lady yesterday, Mr. Turk's counsel was craving on his behalf an indulgence to provide the disclosure that he hadn't provided by the next hearing. You're saying, I understand I'm under this obligation to provide disclosure and I haven't done it, but I will. So it's the correct construction and it was so understood. And as in this case, a further point of resonance with therium is it didn't matter. The construction of the order didn't matter because Mr. Brooke didn't even try. As to management, is a contractual case. It's a decision of Mr. Justice Leggett, as he then was. And it's paragraph 75 and 76, if we cut to the chase, just noting really the relevant discussion begins at paragraph 62. But I need and don't place too much weight on this case. It's a contractual case, but it really does no more than confirm what in my submission is the obviously correct analysis, that where an obligation is expressed to be due to be performed by a particular date, the person under the obligation needs to keep trying if they fail to meet that date.
Yeah.
So and that's just, again, this is the plenty of ways to skin a cat. The breach either happened at the date by which a diligent respondent would have provided the disclosure, or that was the earliest date by which a breach could have happened, and maybe Mr. Turk's breach has happened later. But by the time they happened, he certainly had every understanding necessary to make his contempts committable. And KS Energy, the Singapore decision, which was relied on by Mr. Justice Leggett in Astor Management, really is just consistent with that in the context of a joint venture agreement. So I'm not sure that it adds a great deal to an analysis which is in any event obviously right in my submission. That's the authorities my Lord Justice Lewison mentioned, unless I can assist further. But I mean, I say Solidchenko just makes it clear, and also the judge was right for the reasons he gave. And this court should follow, well, must follow the reasoning of Solidchenko, but I quite accept that if you can analyse it as continuing breach or other continuing obligation, it does not matter. Yesterday, I took you to the transcript of the return date hearing. If my lords, my lady could put away the authorities' bundles for the time being. I hope it will be helpful just to dip back into that transcript briefly for a couple of different points.
Sorry, which transcript was
The
that?
transcript of the return date with Pat Treacy, so it's supplemental bundle tab 37. If we could go first to page 1034. I'm going to take all of the transcript extracts at once just for convenience, but I'll explain why I'm showing them to you as we go. So from line 14, this is in relation to Mr. Turk's obligations in relation to Barton. This goes to proper construction of the order, Mr. Turk's understanding of the order, and the idea that the judge's finding that there was no prejudice if he was wrong on the penal notice point was without any foundation. If I could invite you to read just from, I know you have the point, down to the end of line 22. So I explained it, and Mr. Turk's counsel said he'd heard it loud and clear. I explained that Mr. Turk had obligations in relation to the Barton information in two different ways. Earlier at page 996, I alluded to this yesterday, but Barton is a BVI company, and so the identity of its directors was not publicly ascertainable information. It's a further reason why it's unrealistic to suggest that the penal notice was defective, because Mr. Turk was not named in his capacity as a director of Barton. At the return date, Mr. Turk was saying he didn't know whether he was a director of Barton, and then during the return date hearing, we obtained bank statements from Varengold that showed that Mr. Turk was a signatory on Barton's account, and then Mr. Turk subsequently admitted he was a director of Barton. But that's just context to explain the submissions at line 16 and following that I was going to invite your lordships and your ladyship to read.
I'm so sorry, which page was that?
Page 996, my lady.
996, thank you very much.
996 at line 16.
My fault for not noting it down. Thank you.
Just to the end of line 23.
So you are alleging a breach of paragraph 18, not just a breach of paragraph 17.
Exactly.
Judge, I think, found Mr. Turk liable under paragraph 17.
He did, and he was right to do so, but I'm showing this for the three reasons that I identified. Mr. Turk's understanding, proper construction of the order, and prejudice. It's plain as a pikestaff that I'm explaining the obligations. And then finally in this transcript and on construction of the order and Mr. Turk's understanding. And so from line, if you have page 992, from line 17, I'm explaining the disclosure obligations. And if you see it from line 19, I say, but as your ladyship has seen both in the judgment and the order, there are three essential purposes of the disclosure obligations that have been imposed upon Mr. Turk. And the focus for my lords, my ladies, from line 24, where I talk about the second purpose being usual ancillary disclosure in ordinance of prorogative injunction.
Yeah.
And then if you would be so kind as to read on to page 993, I think you can stop at line 7, but I give further particulars, and the punchline is at line 25 to 28. Mr. Turk was obliged to disclose to the best of his knowledge and ability where Mr. İŞBILEN's money is, and if he does not know where it is, where he last knew it to be, its last known whereabouts, and he has not made the slightest meaningful effort towards doing that. Well, that was right, and the judge so found.
Right.
So Sir Anthony Mann's conclusions that Mr. Turk well understood the order were amply justified by the evidence, and this court should not begin to interfere with them. Subject to any questions from my lords and my lady, I don't have any further submissions on grounds 1 or 2. Ground 3 is gone. Ground 4, only one very brief point. Ground 4 is the procedural unfairness point. Where, following a ground rules hearing, a judge makes clear that the special measures they are imposing are flexible and to be kept under review, the person entitled to special measures cannot fail to raise concerns that the special measures are not working or are not being adhered to, and then appeal on the ground that there was procedural unfairness because the special measures did not work or were not being adhered to. A fortiori, where there is an appointed expert intermediary present who does not raise any issues that are not adequately addressed and confirms whenever asked by the judge that they are satisfied with how the hearing is being conducted.
Yeah.
If Mr. Turk considered the special measures directed after the ground rules hearing to be procedurally unfair, he should have appealed. He would perhaps have faced an uphill struggle given that the expert intermediary was satisfied with the special measures that were put in place, but appeal was the route open to Mr. Turk after the ground rules hearing. And if during the hearing Mr. Turk was concerned that the special measures were not working or were not being adhered to, the onus was on him to raise his concerns at the time. He did not do so even once. I have nothing to add to our skeleton and the points I made in opening. Ground 5, this is the Hawala lie. Very little to add. I was just going to remind my lords and my lady of perhaps the key paragraph of the judgment in relation to the Hawala lie. So in the core bundle, tab 11, page 215. And just invite my lord and my lady to read or reread 234.
Yeah.
We don't have time to go to it, but a really striking feature of Mr. Turk's cross-examination was how happy he was when the judge suggested to him the word sham about these documents and said, yes, that's what they are. They're a sham. He didn't have any embarrassment or shame in that, as the judge noted. This paragraph of itself disposes of ground 5. And the Hawala lie was in issue because Mr. Turk put it in issue. Ground 6, then, as my lords and my lady know, this is about Mr. Turk's liability in relation to Barton and SGP matters. And there is the procedural limb, which I've called 6A, and the substantive limb 6B. The procedural limb concerns the adequacy of the appeal notice, which the judge rightly found to be adequate as at the relevant time, which is the time that the Miles order was made. The judge's analysis of this is quite detailed and spans over from paragraph 64 to paragraph 69 of his judgment. And I'm not proposing to invite the court to read all of those paragraphs now during the hearing, but of course they bear rereading. But if I might just race through them. So page 169 is where the discussion begins.
Then he deals with Iberian at paragraph 72.
Yes, my lord.
Summarises his conclusions at 73.
My lord, yes.
Then he deals with paragraph 16.
And my lord, I hesitate to interrupt, but just to note that 69, the white workman notice is not prescriptive.
Yeah.
And the form of penal notice is not rigid, may be altered to meet the facts of any particular case.
Yeah. So 16 is all about Mr. Turk's personal obligations.
Yes.
And then we've got 17, which the judge deals with at 76.
Yes, my lord. I mean, the short way of putting my submissions on 6A is the judge was right for the reasons that he gave. He was unimpeachably right. It's another unreality to the appellant's case, that they're trying to bring this unattractive procedural point based on the procedure as it now is, not as it was at the relevant time. And so that makes it a bad root and branch as an objection. it's said by Mr.
Wait, you say the procedure at the time. Is this before the rule change?
It's the complaint that was brought before Sir Anthony Mann
Yeah.
related to the guidance as it is now, and the guidance had changed. So it wasn't about the rule. It wasn't just about the. It wasn't about the rule change. It was about.
But the judge quotes rules 81.4.2e and 81.2 at 66 and 66.
And
Those were
those
the
were
rules.
enforced. Yes,
Because
those
I
were
mean, the 81 has changed so often. That
Yes, the versions that he quotes were in force. The guidance that below it was said by Mr. Turk we should have complied with was not in force.
the guidance, what you're talking about, the white book.
In the white book, yes.
Yeah.
And as in just hadn't yet found its way into the white book. And then the old guidance to which my learned friend now refers is, as Sir Anthony Mann said, not mandatory in any event. And stepping back to consider the reality of the situation, Mr. Counsel says that Mr. Turk should have been named 5 times in the penal notice in 5 different capacities, in circumstances where we did not know that he was a director of Barton and could not know that he was a director of Barton. And also Mr. Counsel says that the penal notice should have fitted on 1 page. If we were going to name Mr. Turk 5 times in 5 different capacities, we'd have needed very small font. And then no doubt Mr. Counsel would say we'd breached the prominence requirement. So there's reality needed here.
Do we have a copy of 81.2, all of it,
In the authorities one, and we don't. It's the 81.2 that was in force as at 2020. We can get a copy for my lord.
because we've got the definition of a penal notice, which does say, in the case of the corporate body or the director, you've got to specify the director or officer, but we don't actually have what the rule says about the inclusion of the penal notice.
I think it's 81.4.2e. Order
Is that
included
all?
a
Yes.
penal notice.
Exactly. A penal notice, that's the mandatory provision. And then
It must include a penal notice.
must include penal notice, which it does. But and even that defect can be waived, and the court has an inherent jurisdiction to waive
And
that.
the form of the penal notice is 81.2.
Yes, and he is specified, and the judge accepted my submission below that Mr. Turk is specified because he's named. So he'd have had an argument, or more of an argument, if he hadn't been named personally. But he was named, sorry, he was himself named, to use my Lord Justice Lewison's way of clarifying the debate. Mr. Turk himself was named. So,
Yes, but he was named in the penal notice.
yes,
And you say the penal notice, naming him once in the penal notice was good enough to cover paragraph 17,
absolutely.
which was not an order directed to him.
Yes. And so the judge held. And then the judge said, and if he was wrong, he'd have exercised his discretion to waive the procedural defect, and that's unimpeachable. I've explained why the criticisms of that hypothetical exercise of discretion go nowhere.
Yeah.
It's 72 and 73, as my Lord Justice Lewison identified, are the key paragraphs. And then paragraph 16 obligation, as is said in 74, was directed at Mr. Turk in whatever capacity he might have held the knowledge. That was the point my Lord Justice Lewison emphasised yesterday. '75. This is on SGP. So that we need to keep SGP and Barton separate. SGP is just it's incredibly cut and dried because of the bank statements being in his inbox, and him knowing that no one else had the bank statements and the bank statements containing disclosable information. So
Yes, but the judge found him in breach of 16 and 18.
yes,
That's his own obligation.
his own obligations, and that's he's saying the 75, my lord. It renders debate about liability as a director somewhat academic, save insofar as it goes to the question of whether he should get information which he does not personally hold or have access to, but he did personally hold and have access to the SGP information. So it's another reason why I say this ground's just futile and academic as regards SGP on any possible.
Well, the traction it has is under paragraph 17.
My lord, such traction as it has is under 17, and really it bleeds into the substantive ground to which I will come, and so that my lord understands where I'm going on that. We had a discussion yesterday about the ways in which a director can be liable where a company breaches its disclosure obligation, and I took issue with your use of the term vicarious liability and explained there was a species of direct liability. Yep. It is distinct from the liability under the Seaward jurisdiction. It is a liability that just attaches to a director when they know the company's under disclosure obligation, know information that's disclosable, and don't have what I referred to yesterday as a reasonable belief excuse. And that emerges from a decision of Miss Justice Foxton, to which we referred below and which we have a copy of in your bundle, but to which we will turn in due course. But Mr. Turk himself was directly liable, not vicariously liable, for Barton's breaches because of the principle identified in Integral and then referred to again by Mr. Justice Foxton in Novan's Jets. In that case, Mr. Justice Foxton was distinguishing what he referred to as the body corporate provision, i.e. the direct liability of directors of corporate bodies from the Seaward jurisdiction to commit. And so, but just focusing on the penal notice point, the answer to the penal notice point is at paragraph 76 as regards Barton. And it's the reasoning is just correct in my submission. He's not named as being a director, well, because we couldn't discover that he was a director because of the way he organised his affairs. Nonetheless, he had a penal notice directed against him, knew he'd been a director at the time of the relevant transactions, knew there was no other director in the same position as him, and came to understand he was a director at the time of the order.
Yeah.
And then he says, in the terms of Mr. Justice Luxmore, the order plainly called his attention to the obligations of disclosure and need to comply with them. No sensible recipient could shrug his shoulders and say he did not consider the order to be directed at him in the relevant capacity. That is the answer both to the procedural objection and a further justification of the exercise of discretion that the judge says he would have exercised if he needed to do so to waive any defect. Mr. Turk knew exactly what he needed to do. I told him very clearly at the return date, and everything he did from then on was on that basis. He wasn't pretending he didn't have to give disclosure in relation to Barton. He was purporting to, but failing to give adequate disclosure in relation to Barton. It's really 77 that answers my Lord Justice Moylan's point. There's the sentence beginning, since there is no single prescribed formula. There isn't a single prescribed formula, and Sir Anthony Mann has held the order to be clear enough. That's an evaluative judgment of the sort that I would suggest this court should be slow to interfere with. There is no fault in the penal notice, and Mr. Counsel's point fails. And then come the grounds for the exercise of discretion that Mr. Counsel suggested were missing. And then just really on seriousness, paragraph 78, after the belated acknowledgement that Mr. Turk was a director of Barton, no more disclosure came.
Yeah.
And importantly, and consistent with this continuing obligation analysis, his failings after that date can be relied on as much as his failings before that date, insofar as may be necessary. He knew everything about Barton. He told us almost nothing. Again, he didn't even try. Then 6B, just for your lordship's note, we deal with the substantive limb of ground 6, paragraph 59 and following from our skeleton. I'm not going to repeat or read aloud the submissions there, but would invite you to reread them. But on this point on Integral that I mentioned a moment ago about direct liability of a director, if we could, in the supplementary bundle, please go to our written closing, which is in, I think it will be in your volume 2, probably. It's at page 585 that I wanted to go to. So tab 15. Supplementary 585. No, I want to go to 585.
Yeah.
Basis for liability.
Yeah.
It's B2,
Yes.
and so that's the citation that we gave that the judge obviously had in mind, even though he didn't cite Novan's jets or integral. He may not have cited either of those because it wasn't an issue. A great deal of legal principles were.
Yeah,
Were
and you
agreed.
refer to Tuvalu in Roman 3.
Yes. Well, Tuvalu in Roman 3, and we'll come back to the Tuvalu point to the extent necessary, but I mean, it's the reasonable belief that Mr. Turk did not have available to him on the facts. And integral, to which we may as well turn now, is the answer, I would suggest, of course, although this court isn't bound by it, but I commend Mr. Justice Foxton's reasoning to the court, is the answer to the debate that my Lord Justice Lewison and I were having yesterday.
Yeah, this is in the new bundle, isn't it?
It is in the new bundle, my Lord. Sorry, we hadn't cited it because we hadn't understood it to be
Yeah.
an issue, but it's at page 8, so tab 1 of the new
Yes.
bundle, internal page 8. And just to show you, if you might just read to yourselves paragraph 33.
Yes.
It's that on Barton, which is essentially a one-man company, you can ignore all the factual complexity. It's very straightforward. Mr. Turk knew everything, chose to tell almost nothing. And so that's the end to the substantive ground.
Yeah.
We finished on B.
Subject to any questions my Lord Justice Moylan
I'm
has.
afraid I wanted to go back to A, because you referred to paragraph 77 in the judgment, where the judge said there's no single prescribed form.
Yes.
Might one describe what is set out in 81.2 as a prescribed formula?
Well, my Lord, one might, again, we're into semantic discussion. What Sir Anthony Mann meant, I would suggest, was there isn't a form of words. So there isn't, as at the time that the order was made, there wasn't a sample penal notice saying where it's a director of a company, you need to use these words. And since there wasn't that, there was flexibility. And to my Lord Justice Moylan's question, that is a rule that is prescriptive and needs to be complied with, but the precise form of the compliance is not prescribed. And that, I would suggest, is what Sir Anthony Mann meant when he said there was no prescribed formula. There are numerous ways, numerous formulae, through which one could comply with that prescription.
Yeah.
Do my lords, my lady, have any other further questions on ground 6?
No, thank you.
Ground 7, only one point just to show you in Novan's jets, the paragraph to which I referred yesterday in saying, of course there was harm, there was serious harm. The harm came from the gaps in the disclosure. And so
That's where the judge, Mr. Justice Watson, says the court can't fill the gaps. That one.
exactly. Well, we may not need to turn it up.
I think you got the same in Kawaja as well.
Something very similar. It's paragraph 52. These are extremely serious breaches, irrespective of what ultimately happens at trial, and irrespective of whether Mr. Turk's case that certain transactions were authorised is true. That they are breaches that left the court and Mrs. İŞBILEN scrambling in the dark, and that's the point that is made. So I'm not sure whether that would assist, but it's it's in the authorities bundle.
Yeah, bear in mind you've only got 15 minutes left.
I have that well in mind, my lord. So, and I'm comfortable for time, subject to any interventions that might come. Tab 31 of volume 3 at paragraph 52. We needn't turn it up because my lord Justice Lewison has accurately summarised it.
That's Novans, is it? That tab?
Novans Jets, yeah.
Sorry?
Yes, Novans Jets, yes.
Yeah.
But the short, if ground 5 fails, which it must, that's the Hoala lie ground, then ground 7 fails. But ground 7 fails anyway because there was substantial harm and the judge was right so to find. And the assessment of the seriousness of harm, again, is an evaluative judgment that this court should be slow to interfere with. Ground 8, so we're on to sanction now. Decision not to suspend. The short point is it was an unimpeachable exercise of discretion. The only points that I have to add in that regard are first to emphasise how serious the contempts were and to remind the court that seriousness itself can and often does justify not suspending.
In Templeton, for instance, this court said there was nothing wrong with the sentence the judge passed, but nonetheless, they suspended it.
Yes.
And here, of course, Mr. Turk has actually been incarcerated for, I think, 3 weeks.
I'm not sure it was as long as that.
23 days.
23 days, 23 days.
Yeah, that's
Yes, that's
just over 3 weeks. So that's the equivalent of a 6-week sentence, which he served,
Yes.
which is another factor. I mean, in Templeton, the court had regard to things which had happened between the passing of the sentence and the appeal. And one of the things that has happened between the passing of the sentence and this appeal is that Mr. Turk has served the equivalent of a 6-week sentence.
That is a thing that's happened, but that is a thing that will always have happened where an immediate custodial sentence has been imposed and there hasn't been a stay,
Yes,
and
certainly.
then there's an appeal.
Certainly.
And I would say it would be contrary to principle and contrary to all the authorities urging against interfering with a discretion of a first instance judge to say we're now going to suspend because he's done 3 weeks, which is as good as, well, he's effectively serving a 6-week term. These contempts are so serious that before the judge exercised what I've said is extreme clemency in the light of Mr. Turk's mother's condition, Mr. Turk was looking at a year and a half in prison. Sorry, which would have ended up being obviously half. And so respondents against whom committal orders are made have an appeal as of right, where a first instance judge carefully weighs up the question of suspension and says, no, the respondent should not get a free hit in the Court of Appeal to say, well, I've served a bit of time now, please can the court now suspend? And I'd say that would be quite wrong. And Templeton's an exceptional case. And the only relevant thing that's happened in this case since the judgment of Sir Anthony Mann on sanction is that Mr. Turk has served some of the time, but a very small fraction of the time that he was ordered to serve. My Lord Justice Lewison rightly observed that Sir Anthony Mann did not refer explicitly to the effect on the conduct of these proceedings of Mr. Turk's incarceration. However, it was a point that was discussed during the hearing. The proceedings, for a host of reasons, are still at a very early stage procedurally. So we are a long way from disclosure. And Mr. Turk, who is acting in person, seems unlikely to give much disclosure beyond the disclosure that he's already given. He might, of course, but he's not only given disclosure in accordance with the order, he's tried to give disclosure to support his case. As Mr. Counsel alluded to, he made an application, when he was still represented, he made an application for reverse summary judgment, which was dismissed as totally without merit. But the basis for that application was in large part the documents on which Mr. Turk relied as showing what he said proved his defence. So the stage that's going to happen whilst Mr. Turk is in prison is that we're going to do our disclosure, but we're obviously not going to then get a date for disclosure and say that Mr. Turk is in breach. The only other active parties to this litigation are Mr. Lewis and the companies that he controls, and he's also actively engaging. But the proceedings can be readily managed if Mr. Turk serves 6 months or longer, as I would suggest he should, without any undue disruption to the proceedings by reason of his imprisonment. This is not a case where deadlines for witness statements are pending or there's a trial date fixed or anything like that. So we are not trying to score an illegitimate strategic victory in the main proceedings by having Mr. Turk imprisoned, far from it. And it was a point that was canvassed before the judge, and again, the judge is not obliged to refer to every factor that was canvassed in argument in their judgment, especially not in an extempore judgment.
Yeah.
So unless I can assist further, those are my submissions on ground 8. Yes, I'm just on ground 7. I'm just reminded by Mr. Gerd it is a point worth making that Mr. Turk agreed in the committal application that Mrs. İŞBILEN's evidence as to Softco and AET could be relied on as putting in issue his defence in relation to those transactions, which he then said was a false defence based on sham documents. So Mr. Anthony Mann could never have accepted the Hawala lie as true. He could only either have rejected it as a lie, as he did, or made no ruling in relation to it. So it's just a point of clarification. Then on grounds 9 and 10, subject to any questions from my lords or my lady, I had very little, if anything, to add to the submissions that I made in opening and in my skeleton. And it really boils down to these are attacks on exercises of judicial discretion which are unassailable. There was nothing exceptional in the personal mitigation in this case. Mr. Turk's ADHD and his anxiety are not exceptional factors of mitigation. And to the extent that his mother's condition is properly characterised as an exceptional mitigating factor, it was met with an exceptional response.
Yes, the sentence was reduced by 6 months.
I say that's an exceptional response. It's said by the appellant it was perverse that the judge should have either suspended or given a much greater discount because of it. I say it was within the range. Ordinarily, an advocate in my position says well within the range. I don't say that. I say it was at the outer limit in terms of clemency of the reasonable range, and yet they say it was perverse. So, my lords, my lady, unless I can assist you, I would just commend or recommend to you the submissions we make in our skeleton in relation to grounds 8 to 11.
Yeah.
And I do not think I have anything to add.
Thank you very much.
Oh, sorry, Mr. As ever, Mr. Gers reminded me of one point. Just should my lord, my lady need it, in support of the submission that I made, that seriousness of itself can justify not suspending. We cite Liverpool Victoria as an authority in proposition.
Yes.
As an authority in support of that proposition at paragraph 69 of our skeleton argument.
Yes.
Lord, I'm very grateful to my friend for finishing 5 minutes early. I'm not sure whether that entitles me to take an extra 5 minutes, but I've got quite a bit to get through. And I'm going to deal with them as my learned friend helpfully has by the order in which they appear in the grounds of appeal. So ground one, first of all. It's said by my learned friend that the finding made here was a finding of fact, of primary fact, and the court should not interfere with it. Our case, of course, is that it's not based on primary evidence, it's based on inference. And it may be that the judge reached factual findings, but factual findings from inferences. And that was an inference which it was not safe for the judge to draw. It isn't a case, we would say, of the court being invited to rerun the trial. If a court is relying on inference to the criminal standard, then the court needed to ask itself whether there were reasonable alternative explanations. And one alternative explanation which immediately springs to mind is that Mr. Turk immediately sent the papers to his solicitors, as he did, asking them what he needed to do to comply, which was his evidence. And the reason he didn't comply was because they never told him what he had to do, and more importantly, didn't tell him that he hadn't complied at the relevant time, or advise him what he needed to do to make that right. Leaving aside Mr. Shepherd's email for a moment, which speaks volumes, we would submit, the reference in that email to the appellant's WhatsApp message to Mr. Bechelet shows in our submission prima facie, in a message that he never thought would see the light of day in terms of being disclosed to the other side, that it was a surprise to him that there was any allegation with which he had not, any obligation with which he had not complied. And that is not consistent, we would submit, with someone who was aware of his obligations. There is evidence throughout of every time someone is advised to do something, he does it, he did it. And no evidence in the papers or in the evidence which his lordship held of Mr. Turk being told to do something and refusing. Your lordship referred to the judge's reference to the letter of the 11th of March, and you handed up a copy of it.
Yes.
I don't know whether your lordship's had an opportunity to read it.
Yes.
Can I just take your lordship to it for a moment? Because this is, of course, the letter which Mr. Turk received at the time of receiving the notice.
Yeah.
The order, rather. His lordship said this about it at paragraph 245 of his judgment at Court Bundle 217. He said, the letter summarised the disclosure obligations in terms which I find to be a readily comprehensible and appropriately accurate account. The terms used are terms which I would expect Mr. Turk, with his business expertise, to be able to understand. My Lord, I do say, looking at this letter, that in fact it doesn't do any more than set out again what is in the order when one comes to paragraph 16 to 18. It's just over a 6-page letter. And the reader would get to paragraph 16 to 18 by looking at numbered paragraph 16 on page 4. I suppose it's paragraph 16.2 to 4. And I do say that doesn't do any more than provide him with the information really in the same form as he had received in the order. And it is important, in my submission, to look at what happened next. And when I opened this appeal, I mentioned that there was a chronology of advice received, and his lordship, in fact, described that chronology as being helpful in his judgment. Can I take your lordship to it? You'll find it. I'm certainly not going to go through it all, but the opening events are important after receipt of the order. It's at page 700 in the supplemental bundle. It's quite a long document, took a deal of preparing from once we had all the very nice disclosure. and I'm only going to refer to the first page and then just slightly over into the second. You'll see that the order was served on the 11th. Does your lordship have it?
Yes.
Page 700.
Yep.
The order was served on the 11th, and on the 12th, Mr. Bechelet wrote saying we need to give disclosure as soon as possible, and I attached the areas you need to cover with an attachment, including the Peters and Peters letter, which I've just taken you to, and a draft unsigned copy of a proposed reply from Bivonas, which simply deals with the appellant's assets. Then on the 15th, in an email, a one-line email, Mr. Bechelet says we urgently need to deal with disclosure of assets. So the focus is on a different paragraph, the disclosure of Mr. Turk's assets. First letter from Bivonas to Peters and Peters, again, provides that's a slightly altered version of the one that they'd sent in draft to the client a few days earlier, providing brief information about the defendant's assets and referring to paragraph 7. There's a reply from Peters and Peters to Bivonas about dealing with paragraph 16 to 18 obligations. A further letter from Peters and Peters complaining about lack of information and describing the defendant's approach as fast and loose. And then an email from Mr. Bechelet to the appellant saying we will address these issues this afternoon. The judge inferred that there was a meeting that afternoon, but there's no record of what was discussed. The further letter from Bivonas giving further information about the appellant's assets, saying Schedule D assets represented money loaned by the claimant to the defendant by an agreement in January 2020 and sending a copy of that agreement. Further letter from Peters and Peters, and that was sent on to the appellant on the following day. There's then a handwritten note, which was subsequently repeated in emails to Mr. Shepherd, who'd just been instructed. And your lordship will see that what Mr. Bechelet is principally dealing with there, so far as it's relevant, is assets. And then at the bottom of the page, further copy of that letter, and a little more background is given. Used to work for Goldman Sachs, asked to disclose his assets in excess of 10,000.
Sorry, where are you?
I'm over the page.
Over the page.
Some of these assets were listed by the claimant. These were set out on the 15th of March, an affidavit 16th of March. Relevant parts of Miles J. order was cited in my letter. And then he goes on to deal with the client's assets. And then I finish there because then we go on to the narrative which I've already given your lordship, where Mr. Shepherd is instructed, and we have that exchange of emails where Mr. Shepherd is saying, well, what about his obligations under paragraph 16 to 18? We have all of that. Now, one simply can't draw that from that inference that this was an appellant who was understanding the nature of his obligations under paragraph 16 to 18. One final point, suggested that Mr. Shepherd would have given the advice during the Zoom conference, given advice about the assets. In my submission, that's a little unrealistic. What he much more likely to have done is, look, when we have finished this hearing, we will sit down and I will explain things to you. But we don't know, of course. Ground 2, the continuing obligations or continuing breaches, contempts. The case of Therium is referred to, and your lordship's been taken to paragraphs 30 to 31, which makes clear at 31 that the order imposes a continuing obligation to carry out the required activity. It doesn't, however, put an end to the continuing obligation or prevent the respondent from being in continuing breach if there is non-compliance by the stated time. That is, in my submission, entirely consistent with our case, and it's consistent with the case of Keir. Briefly, if I can take your lordship back to Keir authorities page 802.
Page
802.
Which tab is that?
three.
It's in. I do apologise. It's in authorities 2. It's tab 25.
Thank you.
And what the court said, what Lord Justice Nugent said was, in the second half of that paragraph, the logic of Sir James
Which
Munn's...
paragraph?
I do apologise, paragraph 72. This is after he's referred to the Reed-Jones passage,
Yes.
Sir James Munby. The logic of Sir James Munby's decision is impeccable. I've no hesitation in accepting it. And in accepting that it is in fact heretical to think that a person who's continued not to comply with a mandatory order after the deadline imposed by the order is committing a continuing contempt. We've spoken, my own friend has spoken a lot about continuing obligations and continuing breaches, but the crucial point here is continuing contempt.
Can I just get it clear from you? Do you say the obligation evaporates after the deadline?
No.
So what is the obligation after the deadline?
There's a continuing obligation to disclose. And if there's a breach of that, if there's been a breach which amounts to a contempt prior to the deadline, then there's a continuing obligation, and if it's breached, that can go to seriousness. But the contempt, the breach which arises before the deadline, which could amount to a contempt, has to be before the deadline. And it's expressed quite well, if I may. Your Lordship, I hope, was passed up a case of...
Just a moment.
Could you just ask them to read 75 as well, please?
I'm asked for you to read paragraph 75, which is quite a long paragraph. Perhaps your Lordship could just make a note of that and come back to it.
Thanks.
Your Lordship, I hope, has a decision of Mr. Justice Morris of All England Lawn Tennis Club. I hope that's been handed up with the other authorities. Did you hand it up?
Yes,
yeah.
Sorry, what is the tab?
It's in tab 5, I'm told. Thank you very much.
Tab 5.
This was a case involving a ticket tout at
Yes.
Wimbledon. Can I take you to paragraph 44 or 45. As regards the nature of the obligation under paragraph 3C, the issue is whether after the expiry of the 24-hour period specified in paragraph 3C, the defendant was under a continuing obligation to provide the information and or he was in continuing breach, or whether failure to comply within the 24-hour period constituted a one-off breach amounting to a single act of contempt. And then he refers to the case of Keir. Mandatory injunctions in general require a specified time in which to comply with the order and are to be constructed strictly, given the potentially penal consequences. In my judgment, whilst the point is not entirely free from doubt, I accept the detailed analysis of Lord Justice Nugent. Strictly, therefore, where the defendant was in breach by failing to comply with its terms within the deadline, he was therefore in contempt of court. However, there was no continuing obligation to provide the information. His continued failure to comply with the mandatory order after deadline did not amount to a continuing contempt. What it could amount to is making an existing contempt more serious. And that respect is what Lord Justice Nugent was saying in Keir.
James, you ask them to read 48 as well, please.
I'll ask for your Lordship to read paragraph 48 as well. Yes. And
Yeah.
a number of other paragraphs are referred to. And that is essentially what Lord Justice Nugent was saying. There has to be a breach before, and we say there isn't here, by the 18th of March or whenever it was. And although there's a continuing obligation, if there's a breach which amounts to a contempt, then that can make it more serious. I'm going to just deal with one thing, if I may, in relation to ground 5. It's suggested, the way it was put in Moylan and Skeleton, he's expanded upon this, is that the Hawali point was unheralded and unpleaded. It's neither, with respect. The defence at paragraph 2, can I just give your lordship the reference for now? It's page 901 in the supplemental bundle, specifically put this at issue. It was the defendant's case in paragraph 2 of his defence. Paragraph 2, that she authorised all these transactions.
Yeah.
And Hawali was an example of it. And with respect, it's if a complaint is made, but it's unpleaded, and we would object to it.
Well, we're not deciding that now.
I'm going to skip over ground 6 and 7 and then just come to sanction, if I may, for a couple of minutes. We do say, ground 8, that the judge was wrong to refuse to suspend the sentence of imprisonment. If he was right to conclude that a prison sentence must follow, the thrust of Moylan and Friends' submissions was that one should really only suspend if there was a prospect that that might lead the contemner to disclose. As Templeton shows, there are other reasons why the court might be persuaded to suspend. And that argument that it should becomes even more compelling if your lordship were with me on the Hawali points and were with me on my suggestion that that would thereby reduce the sanction. And your lordship will remember that I took you to the way he'd broken down the sanction. As your lordship has quite rightly said, Mr. Turk has already served 23 days, the equivalent of 46, so already a month and a half. And of course, the court is entitled, and Sir Anthony Mann should have taken into account the fact that prison was not the place for short-term prison offenders if that can be avoided. Those are my submissions.
Thank you.
My lords, my ladies, now my rolled up application for permission to cross appeal and my cross appeal permission is granted. But just before I, of course, put my hands, but I was proposing to make rolled up submissions as well, rather than do a permission stage and then make my substantive submissions. It's really a point of rejoinder, if you'll permit me, just on the pleading. My lords, my lady may already have the point. Paragraph 2 of the defence just contains a general plea that transactions were authorised. In relation to SOFCO and AET, that general plea was then particularised in a way that was entirely inconsistent with the Hawala lie, as the judge found. That's why we rightly referred to it as unpleaded and unheralded as a defence. Our cross appeal then, as my lords, my lady.
On the substantive points on your cross appeal,
Yes.
the judge interpreted the order to mean X. And he found that on that interpretation, Mr. Turk had made adequate disclosure, not fulsome, but adequate. You say that the judge was wrong and that the order means Y. But if Mr. Turk made disclosure on the basis that the order meant X, then even if he was wrong about that, that's not going to lead to punishment by committal, is it?
Well, the devil's in the detail on both grounds, or counts, I would suggest, my lord. In our, if I might deal with this by reference to our skeleton, and I'll answer that question as I go, if I may, because in one sense, the judge interpreted the order, but actually, what he did, to borrow language from vicarious liability, was go off on a frolic of his own by finding his own definition of a term and then applying that definition in a very specific context. And this is a prime example of where one has to step back and assess the broad nature of Mr. Turk's obligations, which was to disclose what he knew. Mr. Turk's not a chancery lawyer and paragraph 78 of our skeleton, we summarise
Yeah.
the facts as found in relation to Bethlehem, and all of those facts were known to Mr. Turk, and letter I over the page, Mr. Turk knew all of the above and had the general details of the yogurt factory purchase in mind at the date for compliance. So when the order was made, obliging Mr. Turk to say the last known whereabouts of the money, Mr. Turk knew that after the money had gone on the purported share purchase, it had then gone to a yogurt factory. But on my Lord Justice Lewison's hypothesis, well, he shouldn't be found to be in contempt or committable contempt for failing to disclose the yogurt factory purchase because of the judge's. If the judge misinterpreted the order, then it can't be a serious contempt. But applying the analysis as it must be applied to a person in Mr. Turk's position, he knew where the money went, and he made no effort to say where the money had gone. And so if what I would characterise as the judge's technical and legally incorrect get out of jail card for Mr. Turk does not work, then this court should find the Bethlehem contempt to be proved. Because when we talked about last step on the trail or last link in the chain, the judge held it's on the facts rather than on interpretation of the order in one sense. Here the trail went cold, or the chain stopped with the purported share purchase. And we go through the judge's reasoning and what we say were his errors at 79. So he started by correctly identifying that the Bethlehem transactions were in play. And then paragraph 18 of the Miles order, I'm looking at C, and the judge accepted our submission that paragraph 18 was not limited to transfers from Mrs. İŞBILEN's bank accounts, and went on to consider how it would apply to other monies. And then D is the key error. The judge, this wasn't a point canvassed in argument at all. The judge got out dictionaries, looked at the definition of proceeds, and decided that money in the hands of Bethlehem ceased to be proceeds. The touchstone was whether there's a seriously arguable proprietary claim. In my submission, and the judge accepted that was a touchstone, in my submission, there plainly was. So this isn't about interpretation of the order, it's about applying that touchstone. Did Mr. Turk know, or was he able to find out? And the answer is he knew the relevant information about where the Bethlehem monies went. Yes. Was that information caught by the order? Yes, for the reasons that the judge gave up until the last misstep that he took, when he decided that money in Bethlehem's hands was no longer traceable proceeds, but arguably, at least arguably, still was. And even if the money in Bethlehem's hands wasn't properly defined as proceeds, and it was still constituted by or derived from the transaction. I mean, this can be tested by saying, well, if rather than not embarking on exercise at all, Mr. Turk had done what he should have done with his lawyers, he'd have said, well, that money went to Bethlehem, and then the question would have come, and where did it go next? In the same way as it's not an answer to say it went to Barton or I put the money in my bath. It's where did it go next? And so Mr. Turk had the information and deliberately failed to disclose it. And the shortcut to finding contempt on count 1 and a broader contempt than the judge held to be proved in relation to count 8 regarding Sverre is the judge's unimpeachable finding that Mr. Turk did not even try.
Yeah.
Because that conquers all. It means that the contempts are proved if my construction of the order is right, and they're committable because of the judge's unimpeachable finding that Mr. Turk did not even try. The words constituted by or derived from are clearly broader than the words proceeds. The whole point of the scheme imposed by these disclosure obligations is to enable Ms. İŞBILEN to identify, formulate and plead proprietary claims and take such steps as she can to protect those proprietary claims pending trial. So, as well as going off on a frolicking zone on the definition of proceeds, ignoring the keywords constituted by or derived from, the judge ignored the underlying purpose of the order in this one respect. And also, paragraph 16(4) of the Miles order, which specified in terms that the disclosure that was required to be given extended to the assets, if any, that were acquired in whole or in part by the traceable proceeds. So the traceable proceeds were the monies paid into Bethlehem accounts, and then the assets acquired with that money included the yogurt factory. The funds transferred to Bethlehem, as the judge recognised, came out of the Sentinel Global Fund, the one-woman fund, and redemptions from that fund were also specifically caught by the order. And so the buying of the factory was a transaction entered into using funds from the redemption. So, for those reasons, and the reasons given in our skeleton, the judge was wrong to hold that the trail stopped with the payment to Bethlehem. The judge rightly rejected Mr. Turk's argument that he was not obliged to give disclosure where he had an arguable defence to a proprietary claim. And that's the territory we're in. Mr. Turk has an arguable defence to a proprietary claim, or the people who own the asset in respect of which Mrs. İŞBILEN has an arguable proprietary claim have an arguable defence. But that doesn't relieve Mr. Turk of the disclosure obligation. In the underlying proceedings, Mrs. İŞBILEN claims that the Bethlehem Agreement is void, alternatively voidable. And those mirror the claim she makes in relation to the payments to Barton, because Mr. Turk seeks to justify the payments to Barton by reference to fee agreements for eye-watering sums that he says mean that there was no proprietary claim because good consideration was provided for the payments. There is no principle, there's a point I made in closing, but the judge didn't allude to in his judgment. There is no principled distinction between Barton and Bethlehem. The judge obviously understood that the proprietary claims ran, notwithstanding the defence that Mr. Turk had raised as regards the Barton payments. And the same logic has to apply as regards Bethlehem.
Yes.
And then I would just emphasise paragraphs 95 and 96 of our skeleton, if you have those open on page 29.
Yeah.
So having correctly identified paragraph 18, the judge then failed to apply it.
Yes.
There's no reference to transactions or investments. So this isn't I'm sorry, it's a rather long-winded answer to my Lord Justice Lewison's question, but it's a necessarily long answer, because the mistake the judge made isn't a mistake that any layperson would make. It's not about ambiguity in the order. A layperson doesn't read paragraph 18 or any of the other relevant provisions and conclude, I can stop when the money goes to Bethlehem. Mr. Turk didn't suggest that's what he was advised. He couldn't because he didn't even try to give the disclosure. If Mr. Turk's evidence had been, my lawyers told me the trail stops with Bethlehem, and the court had accepted that evidence, we'd be in technical contempt territory on this count. But that just isn't Mr. Turk's evidence. There's no basis for that. There's no basis to think that at all Mr. Turk fell into the same error that the judge did, and that justifies his breach. His breach was serious because he knew the information, understood the order, and did not even try to comply with it. And so based on the judge's findings of fact, this court can and should, in my submission, substitute a finding that Mr. Turk was in contemptuous breach as alleged on count 1. That is a very serious breach if proved because of the amount of the payment and the extent of the non-disclosure and the harm. Because not telling Mrs. İŞBILEN where the trail led caused harm because it made the trail go colder. And it delayed or prevented Mrs. İŞBILEN from taking steps that she would have taken if Mr. Turk had done what he was obliged to do. So if you hold that count 1 is proved, as I submit you should, then it would warrant a further sanction. Alternatively, strongly reinforce the existing sanction.
Yeah.
But I say it would warrant a further sanction.
Right.
Count 8. It's really the same point on same points on construction broadly. Count 8 was proved in part on the judge's analysis. So this court might question why I'm even bringing it up. It is for two reasons, two important reasons, and the second I want to mention in relation to Bethlehem. The first is because it is important in terms of sanction if the broader count is proved. And second, it is necessary in my submission for this court to correct the judge's error of interpretation so that Mr. Turk understands what he has to do, both in relation to Sfera and Bethlehem and more broadly, in order to purge his contempt or remedy his continuing breaches or comply with his continuing obligations, whichever analysis this court prefers. The reason why I asked Mr. Counsel to refer to paragraph 48 in the All England Tennis Club case is because there, the contempt being unpurged is expressly referred to. So the contempt's perfected, and then it's for Mr. Turk to unpurge it, and the contempt seriousness only increases with greater understanding and time. So this is not we have sought throughout in every aspect of this application and appeal to be proportionate. We're not bringing these grounds by way of cross appeal for any reason other than because we say sanction is warranted, and probably more important, because we're seeking to clarify Mr. Turk's obligations so that he can provide the disclosure that he should, and to give him an opportunity to purge his contempt, which would be the thing that would make us sympathetic to an application to lessen or discharge his sentence.
Yeah.
So the essential facts as regards Sfera are summarised in paragraph 101 of our skeleton with cross-references to the judgment. And then at 102, we explain the errors that the judge made. And they really, as I say, mirror the errors that he made in relation to Bethlehem. This court can and should, if it concludes that our analysis is correct and the judge erred in the interpretation of the order in the limited ways that I've explained, this court can conclude that Mr. Turk was in contempt on the wider count 8 as alleged for the reasons that we give at 104.
Yeah.
Because he knew or could obtain, it was within his ability to obtain further information about the last known location of the funds, given the facts that the judge found. And again, he did not even try. That answers everything in this appeal. You cannot come to court, to this court, as a proven contemner when the judge has found that you did not embark on the exercise you were obliged to embark on and make these technical points and say the judge was wrong to commit me. The committal order was justified because Mr. Turk did not even try. And then, subject to, do my lord and my lady have any questions on Bethlehem or Sfera? Any further questions, I should say. Then briefly on sanction and cost. Costs obviously just stands or falls with my submissions on Bethlehem. There was a cost discount applied because count 1 was not proved. So the focus of my submissions, which will be brief, is on sanction. As we discussed in my opening remarks in response to the appeal, it's a curiosity that the judge did not impose a coercive element. His reason was given at paragraph 23 of the sanction judgment, was quoted in our skeleton at 107. Mr. Turk did not suggest that he could somehow remedy his non-compliance in relation to the grounds that were an issue in these proceedings. And the sentence in this case is going to be punitive only. One could interpose the words, and therefore the sentence in this case is going to be punitive only. That's I would suggest, what the judge's reasoning was. But it's a non sequitur. Where a recalcitrant respondent in continuing breach, unpurged contempt, does not suggest that they're going to remedy, that's not a reason not to impose a coercive element. It's a reason to impose a coercive element. It's especially, I mean, a fortiori, in a case such as this where committal's really been used as a last resort, there should be a coercive element because Mr. Turk said to the court that when James explained his obligations, he finally understood them. The judge, in fact, found that he understood them since the 18th of March, but he well understands them now. He's had them combed over. whilst he's been in court, and he's had them explained to him by his lawyers and an intermediary and the judge. So now is the time for Mr. Turk to seek to comply. And the way to try to cause him to do so is by including a coercive element. That is made clear by the decision of this court in Solodchenko. We already looked at the relevant paragraphs when I was making good my continuing breach or continuing obligation argument. But there's paragraphs 55 and 56. As a matter of principle, the court should consider what part of the sentence should be coercive. The judge decided none because Mr. Turk says he's not going to try to comply. And as I say, that's a non sequitur. It's actually offensive to the proper administration of justice. The refusal to disclose or the refusal to make any further efforts cannot be a reason not to have a coercive element to the sentence. So
it's a paradigm case of where you need one.
Exactly. A defiant respondent has to be the paradigm case, or a non-apologetic respondent, non-truly apologetic respondent. It was said, this is another point on mitigation that Mr. Counsel makes, but it said, oh, Mr. Turk was contrite. He wasn't meaningfully contrite, because meaningful contrition is, and I'll do what I should have done all along, or I'll start trying. So this is a paradigmatic case for a coercive element. And it's proved most readily in relation to the Hawali lies, because the judge found that those were lies. So where is the money actually? Who did it actually go to? Mr. Turk knows, or he knows more than he's let on. Why on earth hasn't he told us? But they're not confined to those counts. And also, coercion has two distinct limits: coercion to purge contempts that are proved, but also, in my submission, to remedy continuing breaches that haven't been yet proved as contempts. And that's highly relevant in this case because, as is alluded to in the judgment, we pleaded more counts in our committal application than were tried, and then we only, at the judge's urging, pursued some of the counts that were to be tried. So there was a winnowing. Those other counts haven't gone, they've been stayed. But Mr. Turk's defense to those counts was he didn't understand and he was advised improperly. So the defense doesn't exist. I'm not asking this court to find those counts proved. I obviously couldn't properly do that. But the non-disclosures are identified. The money movements, certainly in respect of the counts that were pursued at trial but then not pursued through to judgment, the money movements are admitted. So where is the money? Where we don't know the answer to that, a coercive element would, one would hope, spur Mr. Turk into action or might do so. And it's wrong in principle for the judge to say, well, because he says he's not going to try, I'm not going to impose a coercive element. So in those circumstances, in my submission, first of all, I'd invite the court to grant me permission to appeal, permission to pursue my cross appeal, and then if permission is granted, I would say that you should hold count 1 proved, count 8 proved in full, and then impose a greater sanction than the sanction the judge imposed to reflect those counts, and more important, the coercive element. And the coercive element, as per Solodchenko, should be significant given the seriousness and extent of Mr. Turk's non-compliance. Unless I can assist you further, those are my submissions.
Thank you very much.
Well, with your lordship's permission, Ms. Pugh is going to respond.
Yes, Ms. Pugh.
So our position on the respondent's notice, my lord, is there was no misdirection on the test, or not a relevant one for the purposes of the cross appeal. The construction was not one which no reasonable judge could have come to, and in any event, it really makes no difference to sanction.
The test is surely not whether a reasonable judge could have come to the conclusion on a question of interpretation. Either he was right or he was wrong. It's not a discretionary exercise. The order means what it means.
But it's a question of mixed fact and law, we would say. And so one has to give appropriate weight to the judge's construction on that basis.
I struggle to see how that principle works when we're talking about interpreting a written document, whether it's a contract, an order, a statute, or whatever.
Well, perhaps if I make out my submissions on the test,
Yeah.
then one will see that in any event the judge was right.
Yes, that's a different point.
Yeah, in the approach to construction of these sorts of orders with the penal notice.
Yeah.
But I'm going to start, if I may, with the point on sanction, and that this cross appeal would really not make any difference on sanction anyway. In general, the court will be aware of the approach that Lord Justice Stoser recommended in Coadja to totality, and that is the approach which the judge adopted. That's set out in his sanction judgment at 24 to 28 of his judgment. I can refer my lordship to that if necessary.
That was what he described as stepping back.
Yes, and the judge's approach. Well, we can look at it. It's at page 256 of the sanction judgment,
Yes.
which is tab 12.
Yes, so it's really 29 and 30, isn't it? When he applies totality.
Yes, so you see, he starts off by going through the
Individual counts, yes.
Then he moves to totality. He notes my learned friend's concession that these sentences had to be viewed consecutively.
Yeah.
And also at paragraph 30, he
describes an overall pattern of disobedience.
So that test was the correct test, the judge had it in mind, and the judge applied it, and you can see that from his judgment. There's no chance, no real prospect of the respondent establishing that test was wrong, and even that in any event, there's no real prospect of showing that the judge would have imposed a lengthier sentence as a result of counts 1 and 8 being construed differently. The respondent doesn't address any of those points. On the counts that I referred to at paragraph 24 onwards, the judge refers to counts 3 and 9 as being deliberately misleading. Well, the allegations against him were more serious because Mr. Turk was found to have deliberately misled the court. It was on that basis that we see from paragraph 30 that the sentence was imposed. There is clearly no prospect, looking at the judgment, of similar level of seriousness or severity on counts 1 and 8, even if my learned friend is correct about the construction. And finally, the respondent overlooks the relevance of Mr. Turk's mother's personal circumstances and how the judge dealt with that. The judge did not apply a mathematical discount. One sees that he took more of a holistic approach and gave a sentence in the round, and there is absolutely no prospect of showing that the judge would have made a different conclusion from the fact that essentially in the balance it was unjust or wrong to sentence Mr. Turk to more than 12 months on account of his mother. And it's also important to understand the background to this, because of course the court ought to have taken into account that Mr. Turk was a good character, He had suffered from his ADHD, and Dr. Gupta diagnosed him with having an adjustment disorder brought on by the litigation. He had, of course, been happily married, living with his wife, setting up a new bank with the Bank of England, and then this litigation hit, and he separated from his wife, his children have gone abroad, he doesn't have a passport.
Yeah.
Of course, we say, in any event, 12 months was too much, but on the coercive element, if I can turn to that, the first point is that the judge had this well in mind. It's dealt with at paragraph 23 of the sanction judgment, which is on page 256. There was broadly no error in principle. The second point is that Solodchenko doesn't make it mandatory to apply a coercive element. Solodchenko's authority for the fact the judge must consider whether it's appropriate. But the most important point in my submission is one can see from Solodchenko that it is not a question of increasing the sentence to account for a coercive element, but you set the sentence and then you decide if and whether to divide that up into punitive and coercive. And that Solodchenko says that is for the benefit of Mr. Turk in this case, so he knows broadly what a judge on an application to for release.
Well, the point about that, I think, is that if you apply to purge your contempt, and you do, then the coercive part of the sentence can be discharged, and the punitive part remains. That's I think, the rationale for dividing up a sentence in that way.
Yes. So we were completely in agreement on that, my lord. What we're not in agreement with my learned friend on.
So
is
on
that
on that basis, if Mr. Turk were to purge whatever contempt the judge found, assuming that those findings stand, nothing would be remitted. Is that right?
Well, currently there is no guidance to a judge, but as I understand it, the rules will permit an application to be made if he purges.
Oh yes, I mean, he's entitled to apply to purge his contempt, but if the Solodchenko principle were to be applied to what the judge decided, i.e. it's all punitive, what would be the basis of remittal of any of the sentence?
May I just turn my back? Thank you, my lord. Well, Solodchenko says it's only a guide.
Yeah, no, I've got that
In
point.
any event.
Yeah.
So on an application, on the basis that Mr. Turk has subsequently purged his contempt, in my submission, a judge would be able to depart from the guidance given by Sir Anthony Mann.
So contrition and purging would give you a platform on which to make an application for the sentence to be reduced.
Yes.
In effect.
Yes, in any event, whether the judge at first instance has divided it up into punitive and coercive or not. The fairness point comes from one can speculate that a respondent takes steps to purge, goes through an application, and the judge says no. At least if there's a split between punitive and, says you may have purged partly, but we're not going to discount your sentence. at least under the Solodchenko guidance, that's less likely to happen. So the respondent knows what the incentive is if he purchases.
Yeah.
But it's no more than a guide, and it certainly doesn't add time to someone's sentence.
Yeah.
So the judge's approach was entirely in accordance with authority, and certainly any different approach would not have led to more time. Though I appreciate that it's somewhat odd that we would object to a coercive element, but the evidence was there that Mr. Turk felt that he'd lied and given up the information that he had.
Yeah.
Costs, I don't want to spend any real time on costs. It's a discretionary point. There were multifactorial points that the judge took into consideration.
Well, I mean, if the cross appeal succeeds on counts 1 and 8, then the cost order would have to be revisited, and it's quite likely that no discount will be made if there had been complete success for Mrs. İŞBILEN.
Well, there wasn't complete success even if they succeed on counts 1 and 8, because several grounds were dropped, including 3.
But we would still have to revisit the cost order.
That deals with sanction.
Yeah.
So turning to the issue of construction, I have 6 general points, and then I'll go to Bethlehem and Sfera specifically, but I shouldn't need too much time, certainly not till 10 to 1 on this. The first general point is that, of course, we can't dispute and don't dispute that the Miles order was made, and the question is simply a matter of construction at this point. But that is not to say that we agree that the Miles order should have been made in those terms. It's just at this stage in the legal proceedings, beyond that point, and it's a question of construction. And of course, the scope of the legal aid authority is to deal with the contempt proceedings only. The second general point is that this is not a standard form order. So we're not in a position analogous to the standard form freezing order. So the judge was not constrained by any authority to impose an interpretation, and indeed there's limited precedent value to any of these orders. It also negates, in my submission, the argument my learned friends make that if their construction is not adopted, then victims of fraud with proprietary claims will never be able to obtain tracing relief.
So the floodgates don't open.
No, you just draft it differently.
Right.
Was that submission made? I didn't understand that submission to be being made. I thought the submission that was being made was it was important for the future conduct of this case that the obligations were clearly understood. Maybe I've got the wrong end of the stick.
I don't know about my lady. In their skeleton argument, if I can give you that reference. It's page 122, paragraph 91 of their consolidated skeleton argument, which is at tab 7. Tracing relief would not be effective in practice.
That's a more general point. It's not a point that concerns the construction of these particular obligations, which is what we're dealing with now.
So, well, I read that as saying precisely that there is a general need to construe this order in a particular way.
I mean, that's not how I read it, but anyway, I see the point you're making. Thank you for clarifying that.
But my lady reminds me of of the other point that my learned friends make concerning the need to be clear about what Mr. Turk has to do. And of course, that's a rather circular argument, because if the judge is correct on his construction, then Mr. Turk does know what he has to do. It's only if my learned
Yes, but
friend...
that's the very issue that we're dealing with. Anyway, yeah, all right, I see what you mean.
The third point is that the context of these disclosure obligations being ancillary to a proprietary injunction is important. It's not the same as a worldwide freezing order, where the terms of the disclosure order will be concise in standard form, subject to a pragmatic value threshold, and relates to assets which subjectively are much more likely to be known to the respondent. Here, the respondent's, the appellant in this appeal was faced with far more extensive obligations, not in standard form, so legal representatives can't rely on previous authority, not subject to any value threshold. So if my learned friends are right, and 10 million, 40 million was spent on £1 transactions, then he would have to disclose 10 million, 20 million transactions, however many there were. And the recipient is not being asked about his own assets, he's being asked about assets of the respondent, which are a matter that's very much in dispute in the main proceedings.
Well, he's being asked about money flows. That's what he's being asked about, isn't he?
Well, that's certainly the intention behind the order, yes. This is a relevant consideration because the purpose of paragraph 16, we say, is to hold the ring. Is to support paragraph 15, which is to hold the ring. So paragraph 15 is the proprietary injunction, and in the same way that you have ancillary disclosure obligations with a freezer, the purpose of 16, we say, is to enable policing of the proprietary injunction. Now, it's entirely appropriate that the court gives whatever assistance it can to victims of fraud, and there are many tools available to the court. But the court, of course, has to be cautious about wielding its draconian jurisdiction on contempt. Fourth point, relevant to construction, we say, is that this is not post-judgment. So construing the order with hindsight will be construed against the background of the facts found in Sir Anthony Mann's judgment, for example.
Sorry, I don't follow that at all. Why should the construction of the, I mean, just going back to a point my Lord Justice Lewison made a few minutes ago, how are the facts relevant to the construction of the order?
Well, under the Pan Petroleum test, my lady, the court can have, ought to construe the order against the context, which is defined as including the objects.
But we're talking about an order made by Mr. Justice Miles.
Yes.
And you can certainly interpret an order by reference to the reasons which the judge gave for making it, but I don't believe that we've got Mr. Justice Miles' judgment or that anybody has relied on it to inform the meaning of the order which he made. So whatever Sir Anthony decided is neither here nor there in deciding what the meaning of the Miles order is it?
I think I'm just making a more general point that on construction of these orders, one has to construe them with it in mind that a respondent is not receiving the order and interpreting it themselves against established facts.
Oh, I see.
Point 5, this proprietary injunction and disclosure order was onerous whatever construction was adopted. Sir Anthony Mann recognised that in his judgment. And point 6 is that if the respondents are right, that onerous task would be considerably greater, because there is no logical limit to the different pathways that Mr. Turk would have to track. So turning to the test, and it's only really Ablyazov that I would refer this court to. My Lord, Lord Lewison will be familiar with Pan Petroleum in any event. But in Ablyazov, which is in volume 2, on page 664, paragraph 17. You see about halfway through that paragraph, the question is simply what the freezing order means. If it is desirable that broader meaning should be given to it, then as appropriate, applying ordinary principles, the solution is not to give it a meaning which it does not have, but to vary the order appropriately for the future.
Yeah.
And then, of course, both Ablyazov, Pan Petroleum, and more recently, the Court of Appeal decided in ADM and reiterated that the position is to construe these strictly. Dealing briefly then with the Starson approach, that is completely inapt for construing orders of this nature in my submission.
So I say that again, I didn't hear it.
The Starson, my lord, is relied on by my
Yeah.
learned friends. It's a case on construction of a bill of lading.
Yes.
And it could be seen to broaden the test which I say is applicable. I say that simply does not apply. The test that this court has to consider is set out in Ablyazov and Pan Petroleum,
Right.
which post-date the Starson. So dealing with the case on Bethlehem, if I may, the judge set out the general principles of construction tab 11, page 159. So there you see at the bottom at paragraph 29, the judge refers to resolving ambiguity in favour of the respondent.
Yes.
And then over at 32, the judge refers to Pan Petroleum. And we say that was quite...
Sorry, where does he refer? Oh, yes, I see. Yes, 32. Yep.
32. My learned friends make 4 criticisms of the judge's reasoning on Bethlehem. We deal with those at paragraph 7 to 12 of our supplementary skeleton argument. There was some question yesterday as to whether that had reached the court.
Yes, we've got it.
I'm very grateful, my lord.
7 to 12, yeah?
7 to 12, yes. So, in light of that, I will canter through these points, subject to anything that my lords and
Yep.
ladies wish to ask. The first criticism of the judge is very focused on traceable proceeds.
Yeah, you don't need to read all this out, so just make the points you want to make. So we've got it all in writing.
Thank you. The point to make on this then, or to emphasise, is that the tracking exercise was factual. That was the decision of the judge. So my learned friend's suggestion that it was whether there was a reasonably arguable proprietary claim, and that's how you look at the construction of this order, is completely wrong and completely inapt. The judge said you look at the factual tracing, putting to one side whether there's bona fide purchaser defences or proprietary claims.
Yeah.
So even after dealing with those 4 points, those 4 criticisms, the respondent would have no prospect of showing that a different construction would lead to a finding of contempt. The findings of the judge on Bethlehem are at paragraph 102 of his judgment, which is called tab 11, page 178. So at 102, the court recounts what was disclosed, but only those disclosures made in the immediate aftermath of the Miles order, up to the point of the cross-examination hearing. The judge doesn't continue and consider the other disclosures which were made at a later date. At paragraph 103, the judge says there's no doubt about the discrepancy between the details, but he doesn't find there that the non-disclosure was serious or of such a level that it could be a contempt or would certainly affect the sentence that this respondent actually got, in fact.
It isn't potentially because he didn't get to that stage, because his construction of the order led him to conclude that there wasn't a breach.
Yes. Yes, no, I accept that, my lady. But I'm saying that the this court can't assume what the judge would have found if he had continued that exercise.
Slightly different point. I see.
He wouldn't have, can't be sure he would have found what?
This court can't assume
Yeah.
that he would have found what my learned friends suggest, so that there'd been a contempt on this ground and that it had been serious.
Yes, I'm following. I mean, he says at 102, this is information which Mr. Turk had and didn't disclose. And then he says, well, at 103, there's no doubt about the discrepancies, but was Mr. Turk required to disclose that? And he says, no, he wasn't. That's the reasoning process, isn't it?
Yes, well,
So if the judge was wrong in saying that Mr. Turk wasn't required to disclose what he set out in 102, then it would seem to follow that Mr. Turk had not complied with his obligation.
102 is what he has disclosed.
Yeah, well, yes, but ascertained only pursuant to Miss İŞBILEN's own inquiries and applications well after the Miles order and not from Mr. Turk's disclosure. That's what he says.
That's the above details, yes.
Yeah.
So 101, yes, thank you, my lord. 101 covers what wasn't disclosed, but
Yeah.
102 covers what was in fact disclosed. And that exercise of the judge stops, as my
Yeah.
lady pointed out, logically as a result of the judge's findings on construction.
Yes.
At a very early point, there were further disclosure right the way through even the contempt proceedings. The same points of construction are taken in relation to count 8, so I don't repeat my responses to those. They are set out in our skeleton argument in any event. The final point then to make is that my learned friend keeps referring to unimpeachable findings that the appellant didn't even attempt to comply with his disclosure obligations.
Mm-hmm.
Firstly, that is inconsistent with the other findings of the court, that some attempts were made. So you can see in paragraph 102 that I just took you to, my lord, clearly some attempts were made by the respondent. And of course,
I think the point the judge made, I mean, I don't know, the point the judge might be making is that this all came out in his cross-examination and it should have been disclosed much sooner in response to the order. I think that's what the judge is getting at, isn't it?
well, for pursuant to his disclosure obligations, in his initial affidavit,
Yeah,
he did disclose some information about the Bethlehem agreement.
I see.
I can't quite recall now the extent of that, I apologise. But there was an affidavit.
102 is wrapping up both disclosure obligations and cross-examination.
Yes.
So we don't know from the way the judge summarises it what was disclosed in the affidavit and what was disclosed in the cross-examination insofar as they differ.
Yes, that's right from the judgment.
But what the judge does say in the second sentence of 102, the above details were ascertained only pursuant to Mrs. İŞBILEN's solicitor's own inquiries and applications well after the Miles order and not from Mr. Turk's
Yes,
disclosure.
that's what's in 101.
Yeah.
And then 102 is disclosed pursuant to his disclosure obligations and cross-examination. But we can't separate out which is which.
No.
But whether he tried or not isn't, if I may say so, isn't really the point here. The point is, what was he supposed to try to do?
Yes. Yes. But my learned friend kept referring to unimpeachable findings.
Yes, quite. But if I don't try and jump the high jump, the question is, was I supposed to?
Yes. So to wrap up the submissions on construction, this is a draconian order subject to a penal notice with extremely strong, severe consequences for a respondent. There was clear ambiguity in the order in that my learned friend proposes one construction, we proposed a different construction.
Yeah.
The court decided on a third construction, and it's very clear in the contempt case law that the ambiguity ought to be resolved in favour of respondent, irrespective of subjective belief. That is a principle of construction, and the answer to the fact it doesn't then do what the respondent wants it to do is that it ought to be drafted differently.
Yeah. can I just take you for a moment to paragraph 104 of the judge's judgment? Because I think one of the things that Mr. McCourt-Fritz says is that whatever the judge may have thought about paragraph 16 of the order, he has ignored paragraph 18 of the order, although the summary of grounds, page 270 in our bundle, tab 14, alleges that in relation to Bethlehem, the provisions breached were both paragraph 16 and paragraph 18. And the judge doesn't, at least I don't think, doesn't discuss paragraph 18 in his discussion of this count.
That's correct, my lord. The answer to that is that it is discussed in relation to Sfera, and the key is that the same phrase traceable proceeds appears in paragraph 8.
What's the paragraph in relation to Sfera? We start at paragraph 198.
Apologies.
.207, he repeats what he says about proceeds. Does he discuss paragraph 18?
My notes 215, the contempt judgment. Oh, that's paragraph 3. I do apologise.
Paragraph?
So I'm eliding 2 points. So forgive me. Paragraph 215 is the
215.
paragraph
Yeah.
3 point. So there's an issue taken about whether
Yeah.
he analysed Schedule E correctly. But the answer to the paragraph 8 point.
18, I think it is.
I'm grateful, my lord. The answer to paragraph 18 is that it uses the same phrase, traceable proceeds. So my learned friend's criticism is really one of lack of reasons. But it's plainly clear from the judgment and the analysis of paragraph 16.
Yes.
Thank you. May I just turn?
Yes, of course.
Unless I can answer any further questions.
Thank you very much.
Thank you.
Yes, Mr. McCourt-Fritz.
Really only one point to reply to, 3 points of information. First of all, the judge did consider paragraph 18 in relation to Bethlehem, but did not in relation to Sfera.
Ah, where's he did deal that with Bethlehem? Where's 18?
110.
Sorry?
110, paragraph 110.
110.
But he did not deal with this in relation.
Ah, right, thank you very much.
He did not deal with in relation to Sfera. There was extremely limited compliance from Mr. Turk in response to the Miles order. This is a point of impatient or point of reply as you wish to see it. The limited compliance that there was is summarised in the liability judgment from paragraph 80.
80.
80, just for your note, I wasn't proposing to tell us that. But that summarises the very limited disclosure in the disclosure affidavit, as contrasted with what Mr. Turk then said in the much later cross-examination hearing, when he said all manner of things about Bethlehem, but not the disclosable things. My Lord Justice Lewison asked about the Miles judgment. It's right, it's not in the papers before this court. We'd suggested it should be, but that was objected to. But it's common ground that the relevant passages of the Miles judgment are referred to in paragraph 45 of our trial skeleton, which is in the supplementary bundle at tab 7, behind page 183. What Mr. Justice Miles said about the reasons for making the order is entirely consistent with everything that I've
Lost at the moment.
said, of course.
183.
183, tab 7, paragraph 45. It was tracing relief.
Yes.
And one point of true reply, the reliance on stars in is apt, but only goes a limited way. Mr. Turk, as the judge found, was an expert banker, a very experienced businessman who'd carried out all the transactions and knew all the information. And that's the relevant context for construing the order. That was known by everyone, including the judge, when the judge made the...
But I mean, if you go to Marley and Rawlings, for instance, there's almost no distinction drawn between the interpretation of different kinds of document, and the same is true of a case involving Donald Trump's license. Yes. I can't remember its name now.
No.
But
I swerved that one, my lord. Yes, exactly so. So those are my submissions in reply, unless I can assist further. There was one unrelated point, which is the extension of the all ports warning and the bail conditions.
I thought that had been extended until disposal of the appeal.
Oh, I
Has it
think
not?
Mr. Gurr suggested, I haven't checked myself, Mr. Gurr suggested at the end of this hearing. And if it's until the end of this hearing, obviously, I thought it was until the end of this hearing, subject to an oral liberty to extend.
In the event that the appeal is not disposed of.
Yes. Paragraph 3 of the order of the 26th of April, in the event that the appeal is not disposed of at the conclusion of the hearing.
Page 288.
No, I have looked.
Well, don't go away, because we'll just go out for a few minutes and decide where we go from here. And we'll be back
Thank you very much.
for the short adjournment.
Court rise is able. If you do need to speak, I suggest you.
Yes, thanks very much, thank you.
Thank you.
Is he coming back? You should sign what they do.
There's nothing we need to discuss that can't be picked up by the live stream, so.
Yeah.
When I came back from the toilet, I was awake. I was hungry. So hungry. Any short adjournment? Any short adjournment? I can
Oh, they're not here. Did tell them not to.
Yeah.
Right?
I'll tell them.
Right, we'll just sit down. I did tell you all not to go away.
Sorry, we were told to go outside, so we did. I apologise, my lord.
Right, well, there's quite a lot to think about, so we are going to reserve judgment. You will get a draft judgment in due course, which is your opportunity to correct our English, but not our reasoning. And we will deal with all the matters in issue, both on the appeal and the application for permission to cross-appeal. The hand down will be remote. The draft judgment can only be distributed to those who are properly authorised to receive it in accordance with the terms of the embargo. In the meantime, and pending actual hand down of the judgment, we will extend bail on the same conditions as before, and we will also extend the all ports warning. We would hope that in the light of the draft judgments, you will be able to agree an order disposing of the appeal and the application for permission. If you can't agree a form of order, please make written submissions and we will make the form of order that we consider to be appropriate. In the meantime, would you please agree an order dealing with the extension of bail and the all ports warning pending the formal hand down of judgment?
Thank you, Mark. Might I just address you on one matter in relation to bail? It's your order, your lordship's order.
Yeah.
Was at, well, the relevant part at any rate, was at page 285.
285?
285 in the core bundle.
Yeah.
And at the end of that order, there were two schedules, one of which was substantially amended, but the other wasn't, the Schedule 2, residence condition, and also a condition that Mr. Turk should attend daily, either in person or attend a video call with a representative from Jane's solicitors.
Yes.
We would invite you, well, either to remove that condition, or if your lordship wasn't prepared to do that,
Sorry,
then to relax it somewhat.
Wait a minute, let me just, where is
You're
the?
talking about subparagraph 2.
Yes.
Right.
Yes, at the moment, the requirement is that they should have a meeting either in person or remote every day, which of course
Oh,
includes,
yes, I see, yeah.
which includes weekends and bank holidays.
Yeah.
And I suppose my first submission would be that it may be appropriate now, he's complied with it strenuously every time, to reduce it so that it doesn't include weekends, largely because it's quite an intrusion upon the personal life of Mr. Livingston, my instructing solicitor.
So you're suggesting every working day?
Well, I am, although I'm pushing my luck somewhat. I was going to submit to your lordship that it could be removed altogether, given that he's complied throughout. But that's my application. But principally, it's to remove it from the weekends.
Yeah.
We oppose that application, my lord. You directed that condition after debate between the appellant and the respondent as the appropriate way of balancing the various factors. That balance hasn't changed at all, and if anything, the need for the reporting conditions has become more acute now that we're in the stage between the hearing of the appeal and judgment. It's a time-limited stage. My lords and my lady will know roughly how long in time we are limited, but I would invite you to keep the conditions exactly as they are.
All right, well, we will go outside for a few minutes. Don't go away this time.
Just be mindful if you do want to talk about the case, don't say anything.
No,
You just have to move it.
Court rise of Honeyball.
Yes, Mr. Counsel, we accede to your fallback position. Every day is to be replaced by every working
I'm
day.
most grateful. Thank you very much, my lord. And very final point. Your lordship, or the court asked at any rate, for copies of the old version of Part 81.
Oh, yes,
The 2020 White Book, which we've now got.
yeah,
And also the full judgment of the Singapore
Yes.
Court of Appeal in the KS Energy case.
Yeah.
Can I pass up 3 copies of each?
thank you very much.
Yours is probably better, actually. Going to my learned friend's copies are better.
This is the
more
Singapore
official.
case, is it?
Sorry, one final point, which is on the
I'm sorry?
one final point, which is just on the all ports warning. I understand from those instructing me, it needs to be limited in time, as in tied to a specific date. At the moment, it's tied to
Hand down.
today, I think, and so might it be extended till mid-June? That's sensible.
Well, we'll extend it for, let's say, another 28 days.
Another trustee, I'm grateful.
And I'll give you liberty to apply if the judgment has not been handed down.
Court rise of Abel.
The weekend.
Because then you lost the time.